Welcome back, everyone, to another book seminar within our monthly book seminar series organized by the Hague Program on International Cybersecurity. Within this monthly seminar series, we invite authors to present their recently published books on all matters relating to international cybersecurity and emerging technologies more broadly. My name is Isabella Brunner. I'm an assistant professor at the Institute of Security and Global Affairs at Leiden University and associate fellow at the Hague Program on International Cybersecurity. Today, we're thrilled to welcome our guest, Dr. Matthijs Maas, who will present his new book called Architectures of Global AI Governance: From Technological Change to Human Choice. Given the current geopolitical developments with AI regulation becoming a hotter topic by the day, we're very excited to have Dr. Maas here today with us, especially since he has extensive experience in the field of AI governance. He is a senior research fellow at the Institute for Law and AI in Boston, and his work generally focuses on international institutional designs for AI governance regimes, the effect of AI on international law, and adaptive technology law. Dr. Maas is also an associate fellow with the prestigious Leverhulme Center for the Future of Intelligence at the University of Cambridge, and he received his PhD in law from the University of Copenhagen. So how this seminar goes is that Dr. Maas will present his book for around 30 minutes, after which we will have a questions and answer session where you're all very welcome to ask questions or provide comments. In order to do so, I would kindly ask you to either raise your hand, turn on your camera and ask your question directly, or if you prefer writing it in a chat, feel free to do that as well. I'm happy to read out your question then. So without further ado, I will now give the floor to Dr. Maas. Thank you very much for joining us again today, and the floor is yours.
Thank you so much, Isabella, and I'm very excited to contribute to the book seminar series. It's been a great lineup I've also seen, and framing for this. There's a book. It's a physical book. It's also more conveniently, perhaps also we have an open access PDF, and it's a very exciting time to sort of write on this. For me, what frames this a bit is this question of how can we undertake governance for a changing technology in a changing world when the very sort of tools that we have for international law and global governance may also be under change, whether it's by political change or technological change themselves. And so the framing theme here is, okay, how do we govern globally? How do we govern issues such as AI, as well as other issues at an international level? And how do we do that in a way where we're not sort of driven or constantly disrupted or reacting to technological change, but we can actually have this be steered by human choice? And what are principles and approaches and tools for that? And so it's been a hectic few years for AI governance, obviously, in terms of convening summits, governance initiatives, acts, soft law, domestic regulation. And so, even as of this week, also we've had our next sort of set of convening conferences. And so the question here is a bit, when trying to make sense of that, panoply of instruments and approaches and proposals, and to help us understand what is sort of the best way forward and what are the considerations there, I wanted a way to think about, how do we think about shaping a governance architecture for advanced AI? What are the problems in the first place? Then what are the instruments that we have available? What's the toolkit? What are the design considerations for regimes? And how should this be informed by sort of the overarching regulatory approach that we have? And I also wanted to connect this field or sort of international, global AI governance, international AI governance is a very rich field, very fast-moving field, but it's not always sufficiently rooted or hasn't sort of like, found all of the possible fertile connections to fields such as technology law, fields such as international law, sort of case studies from historical design. And so I wanted to draw those connections more explicitly in sort of domains like global governance scholarship to sort of say, okay, we don't need to reinvent the wheel in AI governance. There is both a lot of very applicable law and there's a lot of applicable lessons about how to design institutions and regimes. And so briefly, the preceding questions, of course, okay, why do we want to have AI governance in the first place, and why does it need to be global? Everyone always wants to have definitions of AI. I think there's not really like a single like proper definition of AI, but of course there's a functional definition of what is an AI stack of different sort of levels at which you can think about this technology, and you can think about it as a sort of conceptually a strategic general purpose technology. It is more sort of technically, it's a portfolio of computational techniques, digital artifacts, so the models themselves, or the physical infrastructure, so data centers and compute clusters, which then deploy these kinds of models to clients, to customers, to users across networks and in processes. Why do we do that? Well, these systems are offering increasingly competent and general capabilities, and what they're trying to do is essentially improve the accuracy, speed, or scale of machine decision-making in these complex environments, with the aim that you can aid, substitute for, or improve over human performance. And that just this enables lots of useful applications across all these different domains. Why is that relevant for us? Well, this creates, from a sort of a legal perspective, it creates new sociotechnical changes, including legally relevant changes in global affairs. International law, or a lot of domains of international law, do not care per se about the appearance of new technology. In that sense, they're quite technology neutral. But if there are artifacts, actors, or activities that have legally relevant effects, or that are a problem from the perspective of various governance rationales in terms of threats to rights, market failures, or threats to international stability, then you want to be sort of concerned and to act in time. It's tricky to talk about AI as sort of a single element, and so sometimes it's useful, and the way I sort of carve it up in the book is to think about it at the level of sort of different technical types of systems, as well as the different political features. And so you have conventional AI, what used to be called sort of like narrow AI, and it's the or predictive AI, including many sort of preceding deep learning based applications. And you can get these systems like predictive profiling algorithms or facial recognition, and you can get that applied in the civilian domain or in the military domain. And in both cases, obviously, there are a set of governance problems that emerge. And then, of course, in the last 4 years or so, we've also, and even before that, we've seen increasing concern for general purpose AI, which is sort of the more large language models based, or what's sort of called like paradigm shifting AI, which is sort of the alpha fold, so systems that are still narrow, but they are actually able to perform at a superhuman level. They're able to detect patterns that we would not be able to do. And again, you can think about these in the civilian domain, or also I think, and especially in the last year or so, there's been a bit more attention to this as companies like Anthropic and others have started to work with the U.S. Department of War now. Although as of this week, that collaboration is a bit more complicated. And so you can think about the international challenges that these systems create at those levels. And my book tends to focus mostly on the military domain uses of both types of AI systems, as well as these sort of like governance for advanced AI systems. That doesn't mean that I'm sort of not concerned by sort of more conventional AI applications. But it feels that in particular the governance gaps for a bunch of these issues for advanced AI systems and large language models are larger within existing national and domestic regulatory initiatives. And so one question is sort of like, why decide today? I mean, international lawyers have jumped the gun on new technologies in the past. In the 1950s, there were debates over, should we have a center of the earth treaty? In the 1970s and a bit before, they were talking about a global regime for weather control. And in many cases, the technologies either didn't appear, or they appeared sort of like a bit later. And so maybe in some sense, the discussion was premature. At the same time, it can help to sort of think about and get the ball rolling on these initiatives early on. And also, either transformative AI is sort of plausibly here, And historical windows of opportunity can quite matter because if there are early failures of governance initiatives, this can lead to either decades of delay in actually getting effective governance, or you sort of, if opportunities like proposals for central international environmental agencies aren't taken up in an early stage, you can end up with a regime that is governed, but it's very fragmented, and in some sense, it can be very conflictive. There's many different initiatives that are not collaborating very effectively with each other. And so choosing this right initial structure for this governance regime can be quite critical to its long-term success, because it's not always easy to amend or course correct later. And so to sort of take a step back and think about this trajectory of AI governance to date, and it's a bit impossible to do very detailed, exhaustive sort of narrative. So it's to simplify a bit, splitting this up again in the conventional, military, and advanced AI governance tracks. We've seen since around 2015, maybe a little bit earlier, a wide cluster of initiatives, a lot of it initially in terms of AI ethics principles, but then also gradually a take up of these issues at the OECD, what used to be the Global Partnership on AI and UNESCO, and thinking about sort of the narrow AI systems and the use in domains like policing, surveillance, social credit ratings. And of course, also, that is both soft law, but also I think in the last few years, we've seen more hard law or binding hard law, both at the EU AI Act, the high risk provisions, as well as the Council of Europe Framework Convention. And I think I'd argue that some of these are sort of quite, they're sensible in terms of their impressive successes. There are some outstanding challenges over the implementation of some of this and the compliance question. I think there were follow-up studies on the OECD principles and the UNESCO recommendation, which found a fairly low rate of sort of signatory countries actually acting on implementing and working with the OECD, for instance, to implement these principles. Perhaps it's still early days, but at the same time, this is now over half a decade old, almost. Separately, and even earlier in some sense, there is a track on military AI governance. Interestingly, in the early 2000s, there was an abortive early attempt to try and kick this off, but the human security agenda didn't quite pick it up. There's different debates. I think Carpenter has an interesting book on lost causes, why killer robots didn't jump onto the agenda until the late aughts. And part of that is sort of, people were more focused on cluster munitions. And part of that is also that at the time in the early 2000s, this felt maybe more futuristic. But from 2009 onwards, and especially around 2014 with the UN CCW and eventually the governmental group of experts, you get a set of initiatives that focus on military AI. And there's some focus, the initial domains focus a lot on the lethal autonomous weapon systems, so fully autonomous killer robots. In the last few years, we've seen a broader spectrum of attention to also sort of the use in target selection systems like Lavender, the Israeli system. The one challenge here a bit is that so far a bunch of these initiatives have been a bit gridlocked, especially at the conventional weapons. They haven't effectively held the door on developments in lethal autonomy in war zones like Ukraine. And in the last few years, you see a bit of a shift towards non-binding, sort of bottom-up, sort of like best practices and standards, like the Global Commission on Responsible and Ethical AI in the Military Domain, or the US Political Declaration. And as of, I think, last week, there was the 2026 Spain summit of the GC regime. And in fact, only, I think, a third of the attending countries signed up to the final statement, and the US and China very noticeably did not. And then I think we have this sort of third track on advanced AI governance. Advanced AI is sort of not just mine, but it's a bucket term to encompass what's sometimes called frontier AI, sometimes called foundation models, large language models, general purpose AI systems in the EU AI Act. And these are increasingly capable, general purpose systems. There are concerns about, what kind of risks do these pose from potential misuse? So in the supporting bad actors in creating or synthesizing bioweapons or chemical weapons from models themselves. So how would they react as they get more capable and agentic? And are there ways where you can where you can sort of get a loss of control of these models? And I think Rand has a few interesting reports now since a few months ago. And what are the systemic effects if you get systems that are served at scale to millions or tens of millions of users? And there are subtle effects in what kind of news they focus on, or what kind of social or emotional dependencies they create. And again, you saw some early shifts at the EU AI Act sort of to extend the negotiations to cover general purpose AI, and that then translated itself into the code of practice drafting that should be until from 2024 to 2025. And you separately, there are a bunch of sort of, very sort of limited either sort of industry levels or frontier model forum, or there were initiatives at the UN, at the G7. I think most noticeably there was the AI Safety Summit process over the last few years. One challenge of this track is that to date, and especially the AI Safety Summit process has been somewhat contested, and you saw Paris take a very different direction away from mitigating frontier risks towards just sort of like, how do you accelerate this and implement it as quickly as possible? You see India currently bringing safety back on the agenda, but also broadening the agenda very significantly to bring many other issues also in scope, which of course is sensible and understandable, but also creates the risk of agenda dilution. And so in all, this track record so far, has been on one hand impressive if you actually think about sort of what's been done in a bit over a decade. But we've seen, and this is of course not unique to AI governance, but to many domains of multilateralism and international law, a bit of a shock to many of these governance initiatives since last year. Many of the existing regimes are still non-binding or have implementation problems. Their membership is often fragmented, so you get a lot of like club initiatives. There's underrepresentation of the global south in a number of these domains. And there are, as in other domains as well, but still maybe more problematically in the case of AI, given how general purpose and cross-cutting the technology is, there are separate tracks to civilian security applications, even though civilian large language models, for instance, are then sort of being plugged in or used into military applications in some cases. Now, one way of thinking about this is just from a toolbox approach, and this is sort of the first half of my book is focused a bit on setting out the playing field. What is happening with AI what's happening in AI in chapter 1? What are sort of the lines of evidence of thinking about whether this is a bubble or whether this is going to be extremely significant? What are the debates over how you evaluate the benchmarks as a model? Chapter 2 then focuses a bit on what has been what is the set of issues that these systems pose, and why is governance actually both necessary and feasible? And chapter 3 then discusses what is the track record of governance to date, and what is the toolbox and the set of proposals for the road ahead. And so one way is just very, very practically thinking about, this toolbox includes unilateral state actions. You can have expert controls. We've seen this being used a lot. You can have signaling and pressure and threats, and of course, sort of the economic pressure and coercion. There's not usually sort of conventionally bracketed within the confines of multilateral governance, of course, but it is a lever of influence that states, and including frontier AI states or advanced AI states, can use. Of course, from my sort of professional bias, that is suboptimal. It's quite adversarial. You risk miscalculating other actors' reactions to it. You can spoil the political conditions for using any other tools. There are other unilateral sort of national policies that can be used. So there's, again, of course, like regulation with extraterritorial effects, whether that's a sort of a Brussels effect, or whether you try to regulate not the model providers, but intermediaries such as cloud or hardware providers. This sometimes then, does assume that you have an adequate pre-existing legal framework you can project outward, and there are debates over, well, okay, what would the EU AI Act's Code of Practice on general purpose AI systems, to what extent does that get, is that signed by the relevant frontier labs? And unless if I'm mistaken, I think currently, some of the US labs or companies have signed the Code of Practice, but not all of them. I think X hasn't. And none of the Chinese labs, I think, have signed up to it yet. Another sort of approach that states individually can take is to sort of unilaterally reinterpret existing treaties to apply to AI, or to sort of understand how they apply to AI. But again, this assumes that there are treaties that you plausibly can extend and amend to cover them. And if other states don't quite agree with this interpretation, you have a risk that you split the treaty regime, or you get sort of a partial amendment that only applies to some states. There's, of course, you could continue to depend on non-binding global soft law, and this has an important role to play. And there are ways to make soft law indirectly binding by sort of having regulation refer to it as a sort of offering a presumption of compliance. But it's non-enforceable, and in some domains, I think I remember in the chemical industry sector, I forget the acronym specifically, there were cases where, especially if it's sort of solely drafted by maybe industry or organized within industry, there are cases where it actually worsens the compliance track record of participating members. I think that the Code of Practice seems maybe more robust to this, in the sense that it has been drafted with a more inclusive process, including more civil society actors. So maybe it averts some risks of regulatory capture. There are still ultimately challenges where if you speak to certain stakeholders, there are concerns that, well, some labs will just at some level be willing to eat the price of fines, or basically withdraw from a code of conduct. There are bilateral agreements within this toolkit. You can have confidence building measures. I think this is maybe a bit more focused on sort of the military AI or cyber security relevant cases. And I think I'd actually be curious in the Q&A discussing or hearing from Isabella also in terms of international law applicable to sort of cyber security. You can think about pre-deployment agreements for particular very capable AI systems between states to sort of avoid escalation. So things around ideally you would maybe not have systems to be deployed around nuclear command and control or in nuclear targeting or things like that. But if you are going to have certain kinds of systems that you have clear signals and agreement over, well, which targets will not be, what are not valid targets for our cyber warfare AI systems if we are going to actually deploy them. Or if you, and this is in the general sort of CBM, the confidence building measure toolkit, well, let's think about having deconfliction hotlines. This is relevant to some, but not all AI risks. It's worthwhile to invest in this and to think about also sort of emergency response measures, but it leaves a large part of the space uncovered. Then there's, of course, a set where, well, you can just apply existing international law. And to be fair, many AI researchers will look surprised because they're a bit international law is drafted so long ago. And obviously people weren't thinking about AI and robots. And so why would it be relevant? And so, well, treaty law does establish a range of directly or indirectly applicable obligations. In some cases, it just already regulates particular sort of parts of the AI supply chain or development process, whether it's data collecting and processing protections. In some cases, you have rules that are applicable, but it's a bit unclear how they are to apply. So debates over, well, how would you classify the provision of AI systems or AI advisors? Is it a good, in which case it's under the GATT, or is it a service? You put under GATT, and does that even make sense to frame it that way under trade law? How do you classify autonomous ships and the right to hot pursuit under the UN Convention on the Law of the Sea? And yeah, can self-driving cars be included in the road traffic conventions, given that those conventions strictly specify that a vehicle should have a human driver? And this is, of course, the bread and butter of international lawyers. And beyond treaty law, of course, you can also just apply it to customary international law, which is, yeah, broad. It has a wide range of cross-cutting obligations under human rights law, disaster law, international criminal law, humanitarian law, and so forth. And this can provide quite a lot of good guidance. The benefits here is it's technology neutral and it's widely accepted through state practice. It can be vague, and whether and how it applies to AI, yeah, is sometimes unclear and contested, as we've seen in the military domain also. So things sort of like, yeah, are autonomous weapon systems capable of discrimination between targets, between sort of combatants and civilians? Are they? Is there something that is sort of intrinsically disrespectful to human dignity in the use of machines for machine killing? And so while these norms can provide a lot of guidance and also a lot of sort of secondary rules around the attribution of behavior to states, especially if you have sort of autonomous systems, well, under what circumstances are these systems and their actions just attributable to the state? It does need some interpretation and state, yeah, recognition of that this is the law. There's a quick plug for our next book, and I think actually one of the co-authors might be on the call as well. So it'd be fun to like chat with him also. But so our next book is going to look at a lot of how existing law and obligations, yeah, how you can clarify and concretize what these obligations under both treaty and customary international law are and how they apply to advanced AI risks. A separate track thinks about, well, how can you, yeah, if existing international law, I mean, it does apply, but if it's not clear how it applies, well, what's a roadmap towards clarifying it? You can rely on international courts, jurisprudence, and yeah, that can be useful. It can be reactive and slow sometimes. And also there are cases where attempts by either courts or states to sort of try and analogize a technology to an old category, yeah, may not pass the laugh test. And I think Rebecca Krotov has discussed some interesting cases where people tried to apply the Hague Conventions and the restriction on bombardment from balloons I think it's in the 70s or 80s, and they tried to apply it to say that, well, you're not allowed to have orbital bombardment satellites. And in some sense, you can, yeah, see the rationale, but in some sense, at some point, maybe the analogy, yeah, is a bridge too far. And then yeah, let's see, I should speed up a bit also. A different track is that, well, maybe we'll just see a gradual accumulation of new state custom on the basis of their norm development, just as we saw with hostile cyber operations. States will just sort of amongst themselves develop, yeah, patterns of expectations around what acceptable behavior is, and that will then, yeah, eventually translate into what the norms and what also state practice and the law essentially is. Interestingly, and Talita Diaz, who's now at the Partnership in AI, has done interesting work on that in a cyber context, is you can accelerate this process by working out handbooks on developing a national position where you just ask lots of states to issue how they think international law applies to this new domain, whether cyber activities or AI, and you give them maybe a checklist. And you're not telling them what to say about how international law applies, but yeah, you are helping them converge on this and creating more evidence of what states think the international law is. Then there's a set of toolbox that has gotten a lot of attention in the last few years, although maybe less sort of enthusiasm currently, although I'm still curious to see what the options are there on what are new international institutions or regimes. Part of it could be just trying to adapt existing institutions, and there's a lot of energy there. There's a lot of focus within domain-specific treaty regimes, such as on the conventional weapons or civil aviation or the International Maritime Organization. The challenge there is that they are maybe a bit fragmented in particular domains of use, and that may not easily capture the fact that these underlying systems, have cross-domain uses. Then a approach is to think about sort of new regimes, and there are a lot of proposals for what a new treaty for AI should look like, or new international institution, and should be more like, and there's a lot of use of analogies here. It should be more like the IPCC, and be a scientific consensus building institution. Should it be more, like the IAEA, and sort of set and monitor and enforce standards. There are challenges over how politically viable that is, especially given the currently, the US has walked back its eagerness for new institutions a lot. It has also walked back its excitement for sort of UN or multilateral fora. China has been a bit more focused on AI governance through the UN system, where it sort of has more weight within a coalition of sort of states that it has influence with, but it similarly hasn't seemed to express a lot of enthusiasm for new formal intergovernmental organizations. But still, it can be useful to think about what are the modules for a convention, whether it's a single convention or a framework convention, and what are the components, and how would it fit into a existing regime. But there are some questions here that, if we think about new regimes, how does that fit into this larger regime complex of different states? And so finally, the remaining half of my book sort of thinks about, okay, this is the landscape, these are the problems, these are the tool set. How do we improve the way about thinking about which of these tools is suitable? If we pick a particular tool, how do we design it well? And so I draw on global governance scholarship, technology law, and a lot of sort of case studies from history to think a bit about how do we craft this governance architecture? And governance architecture is very broad. It's public and private institutions that are active on a domain. It's organizations, regimes, principles, norms, and decision-making procedures. I mean, that's very broad. But we can still think about, how, when we think about this landscape of institutions from, the UN to the Frontier Model Forum to the OECD, how can we move perhaps beyond sort of individually what is happening in this particular domain or this regime or the framework, the Council of Europe Framework Convention, and how do these different instruments relate to each other? Are there places where there are parallel issues and parallel levers on the same AI issues or use cases, but one of them regulates data and the other regulates climate emissions and the other regulates end users? Are there complements where they can strengthen each other's operation? And this is maybe especially useful given the pressures on multilateralism. Or are there places where these norms could be competitors and work at cross purposes? And I think one proposal I've heard, although I don't have maybe strong views on, is there's Marco Almada at the EUY, I think, still has some papers that suggest that, the EU AI Act was very focused on product safety framework. The Council of Europe Framework Convention has a very sort of fundamental rights paradigm, and that there's some sense in which their norms may not easily align very well, and that in fact there may even be a risk that through its participation in the negotiation of the Council of Europe Framework Convention, the EU kept trying to import aspect of its product safety sort of model from the EU AI Act as the negotiations are going on, and that there's a risk that basically this could create a Brussels side effect, as he calls it. And then also, if you have this sort of larger set of the governance architecture, because you can think about, okay, what are the gaps within this landscape, and what are the overlaps where either normatively or institutionally there can be different sort of different institutions articulating different meanings of the term meaningful human control, or different thinking in governance architectures, as these chapters look at, it can help us think about, what is the best regulatory approach for different issues, unilateral, unilateral, multilateral? What is the appropriate instrument choice? What is the best instrument design? Where is sort of technological neutrality appropriate or useful, and where is that too vague? And yeah, and how can you coordinate amongst these initiatives and what's called like orchestration? So how can you ensure that these, if we are going to have a fragmented regime, how do they work well together? Um, and it can help us understand. I mean, like, what are the goals here? The goal is efficacy. So can these institutions achieve their own goals as they sort of define them to themselves? How can they be resilient so that they aren't blindsided by next shocks or paradigms in AI? I mean, one example here is sort of the fact that the EU AI Act, during its negotiations, suddenly had to account for general purpose AI systems. And it was able to do so, but then it did so in a way where it focused on pre-training compute thresholds. So how much computing power have you used to train this model? And that was relevant for a period. I mean, it was never always going to remain always relevant, in the sense that at least you needed a mechanism to adapt to this threshold because, Moore's law continues and algorithmic improvements continue. So you can currently, train a model with much less computing power to be as capable as a 2023 language model. But also beyond that, the last year or a bit more than a year have seen sort of the development of like inference, sort of reasoning models, which leverage extra computing power, not at the training stage, but at the usage stage to sort of get better results. And so we want a way where our legal regime is resilient and isn't confused by constant change. And finally, you want coherence in the norms. And so finally, sort of my book sort of looks at, well, you can think about resilience, you can think about efficacy by applying what I call a sociotechnical change lens. You can think about resilience by thinking about what are the ways, the particular categories in which AI systems can create new situations. Where and how does that confuse existing law? Is the existing law certainly over-inclusive in a way we don't want to? Is it under-inclusive? Are enforcement assumptions of the existing law violated? But also, what are the opportunities and how you can use AI systems in support of international law in terms of monitoring or enforcement? And how can you think about, what are the institutional models that are feasible for different AI governance regimes? And what are the consequences of having many institutions look at separate pieces of the puzzle? I will skim through this a little bit to sort of allow more time for questions. But so the question here is basically, thinking about social technical change, I argue, helps us think about what we're actually trying to regulate. Is it new technology per se, or is it the actors or activities or artifacts? Why do we want to regulate in a particular case? What is the governance rationale actually? When do we want to regulate? So, when should we tie that to trying to predict where the technology is going, or should we sort of try and just wait and see? And what is the best way to regulate at what level in the supply chain and use chain of AI systems? The second lens is thinking about governance disruption. So in what ways can new uses of AI lead to legal confusion? And where and how can you then change this, either by adaptation, amendment of law, by using legal analogy in a court context, or just by drafting new law? In what ways can international law be strengthened by the use of AI systems, and what are the ways that AI systems can erode the political foundations of international law, because states perceive that, well, we can project international, we can achieve international goals not by multilateralism and goals sort of solidarity, but rather by sort of a more hard power use of AI capabilities. On the second category, there's also some follow-up work that I've since done on the notion of treaty following AI, getting AI agents to themselves interpret and follow treaties. And then finally, the third lens looks at regime complexity. So what are the trends in international law towards seeing more erosion or fragmentation of different institutions? And what are the effects of also the automation of international law on this trend? And what are the political and functional consequences? So, if there are tons and tons of fora and institutions, what kind of forum shopping opportunities does this create for states to sort of try and move debate to the fora where they have they can set the agenda? Conversely, if an institution is very centralized and integrated, well, maybe then it's very politically powerful, and it can avert forum shopping, but it is slow to establish, and it may be hard to amend its mandate after it's established. And of course, if you've got a technology that changes quite quickly, that is a risky bet to make. So in sum, I think there's many available tools still to shape the governance architecture for AI, and there's the pressure to do so. The inevitable or sort of the unreflective use of some of these tools could lead to further backlash, or down the line leave you with a lot of sort of norm conflict. And I think it's useful to think about this and draw on these existing fields of scholarship, even those that haven't directly thought about AI in the past. So, or like some domains of regime complexity theory or other paradigms in technology law, in thinking about how you craft AI governance architectures. So this is the book.